So today we're diving into this stack of legal analysis from HTW Law, and it paints a really chaotic picture of Ontario employment law, basically from 2020 onwards.
Oh, absolutely. It's become this all or nothing game.
Right. The courts seem to have decided that if your employment contract isn't perfect, I mean legally flawless, it's worthless.
It is. And employers are finding out the hard way that a single illegal sentence, maybe in a paragraph they didn't even use, can turn what should have been a 2-week severance into potentially 2 years of salary. It's a huge liability.
So let's get into it. I think the place to start has to be the Waksdale bombshell from 2020. That's the case that really nuked the whole landscape for employers, isn't it?
It completely changed everything. So with Waksdale, you have an employee who was fired without cause.
Okay.
The company used the without cause clause in the contract. And that clause on its own was perfectly fine.
But that's not the whole story.
No. The problem was, elsewhere in the contract, there was a for-cause clause that was illegal. It violated the Employment Standards Act, the ESA.
And the kicker is, they didn't even fire him for cause. It was a hypothetical. They used the valid part, but the court looked at the invalid part and just threw the whole book at them.
Exactly. They treated the entire termination provision as one single thing. If one part is illegal, the whole thing is unenforceable.
Even with one of those severability clauses, the ones that say just ignore the bad parts.
Yeah, the court smashed right through it. They said you can't just sever the illegal part to save the rest. The whole organism dies.
So the employee got common law reasonable notice, which is, way more extensive.
Exponentially more.
Okay, so if Waksdale was about strict technical wording, the next case, Render v. ThyssenKrupp, feels like logic takes a holiday.
Yes. The butt slap case. This one really tests the boundaries of legal definitions.
It seems like a huge disconnect. You have a 30-year employee who slaps a female coworker on the buttocks. The court agrees it's just cause for firing.
Which it is, of course.
But then they rule the company still has to pay him his ESA termination pay. How does that work?
It all comes down to the very specific legal definition of willful misconduct under the ESA.
Okay.
The court found the slap happened in the heat of the moment. For misconduct to be willful, it has to be pre-planned, deliberate. There has to be an intent to do wrong that's more than just a momentary lapse.
So being reckless and unprofessional isn't enough. You have to plan to be a jerk.
In the eyes of the ESA, for the purpose of denying basic termination pay, pretty much yes. Since it wasn't a calculated act, he was still entitled to his 8 weeks. The bar is just incredibly high.
That is a tough pill to swallow. Which brings us to Default v. Ignace in 2024. This one is where a simple drafting error turns into a lottery win.
This is the case of the very expensive phrase, sole discretion.
Right. A fixed-term contract, the employee is fired early. The contract gave the employer sole discretion to terminate. Sounds completely standard.
It does. But the court ruled it was illegal because it implies the employer could fire someone for a reason that's protected under the ESA, like a reprisal for taking a leave. It didn't have a carve-out.
So because that one phrase was flawed, the entire termination clause was void.
Exactly. And since it was a fixed-term contract with no valid early termination mechanism left,
the court awarded him his salary for the entire rest of the contract.
101 weeks of pay, over $157,000.
For work he never did. Wow. It just keeps coming back to that phrase you used.
Flawless or nothing. That's the standard now. Yeah. If you're an employer and you're using a template from, say, 2019, you're probably sitting on a ticking time bomb.
And on the flip side, if you're an employee, that piece of paper you signed, it might not limit your rights nearly as much as you think it does.
But it does leave you with a lingering question, doesn't it?
It does.
If a 30-year veteran of a company gets paid after a workplace assault because his actions weren't pre-planned, has the pendulum swung too far?
Right. Has it become more about legal technicalities than about common sense? That is the very expensive question to mull over. Thanks for diving in with us.